Willingly, Mr. President.
Thank you, Mr. President. May I know if the theory behind this proposed Senate resolution is that the holding of the joint session in cases of martial law declarations and suspension of the writ cases is automatic or mandatory?
That is the position, Mr. President, of this representation.
And I've noticed that
And and we mentioned in our sponsorship speech, Mr. President, that the Supreme Court ruled, or
Yes,
at least the words used by the
that's-
Supreme Court, would be to the effect that the role of Congress to review is automatic.
that is what I gathered, that the one of, or maybe the basis for such a theory or a position is that there is a case, this Fortune versus Gloria Macapagal Arroyo case.
That is correct, Mr. President.
But
That is the only. That is the
Yes,
only Supreme Court decision that touches on the declaration of martial law under the 1987 Constitution.
I have read this case in the original, and that's why I have a problem if we keep on citing this case, because the ponente himself weakened his own decision, or very clearly stated that from the start he said that this is moot and academic because the proclamation has been withdrawn, and at the end he also said that the court dismisses the consolidated petitions on the ground that the same have become moot and academic, and in between those two statements would be 5 times he would say that this case is moot and academic. So I have a problem if we will now base our position that the calling of the joint session is automatic based on a Supreme Court decision which admits that the case is moot and academic. Hence, the pronouncements that we are quoting from the decision did not have been made at all to dispose of the issue or of the case. In short, for us lawyers, anong tawag mo doon, Sani? Obiter dictum.
Obiter dictum.
Yes.
Well, Mr. President, we agree that precisely the ruling was that the matter was moot and academic. But it is not only the case that we are citing that we would like to push in terms of supporting our argument. The other, of course, is the legislative precedents. When it was declared, when martial law was declared in 2009, there was an automatic convening of the joint session of Congress. So if we are to go by precedents, legislative precedents, under our rules, in the absence of a specific rule on the matter, legislative precedents would also be basis, and therefore we are also asserting that when martial law was declared in 2009, immediately there was a joint session of Congress, and although again it became moot and academic because martial law was eventually lifted.
But then my counter argument is that probably we cannot compare our situation today with the situation way back in 2009, December 2009, because as researched by Senator Subiri, that was resolution number 217, and the title, which would give us an idea of what it was all about, says that resolution expressing the sense of the Senate that the proclamation of martial law in the province of Maguindanao is contrary to the provisions of the 1987 Philippine Constitution.
Yes, Mr. President, I drafted that resolution actually.
Yes, so therefore, in that particular case, I'm sure that since the Senate adopted this position, which reveals its intention to revoke, then definitely there was a house, at least one house, which requested the other house for a joint session. So it's not because they think it was automatic that they hold the joint session, but there was a house, and I can pinpoint to the Senate, which I am sure requested for that joint session with the House of Representatives. So, unlike today, this Senate cannot produce or does not have a resolution stating that the proclamation is contrary to the Constitution. Actually, what we just passed is that we have no intention to revoke.
Yes, Mr. President, it's a good thing this resolution was raised, by this Senate President, because I drafted this resolution. And I went around and personally asked the members of the Senate to sign this resolution. And if you are to read the title of this resolution, it says, a resolution expressing the sense of the Senate that the proclamation of martial law in the province of Maguindanao is contrary to the provisions of the 1987 Philippine Constitution. Mr. President, I precisely crafted it in this manner and did not provide for a position that we are intending to revoke or that this means we are going to revoke the martial law declaration, because I believe then that any talk about revocation is not, should be discussed in the joint session of Congress.
Right.
And therefore, not in the upper chamber. If, for example, Mr. President, our intention was to revoke, then we would, and believing that the Senate as a body can tackle and debate and deliberate on the matter of a revocation outside of the joint session, I would have placed that as part of the title, with the end in view of revocation. Precisely because, Mr. President, we believe then that the proper jurisdiction on the matter of discussing revocation is not in the upper chamber, it is in a joint session, which is what we felt was precisely the intent and mandate under the Constitution.
My only point is that we cannot use legislative precedent or past practice because it's actually poles apart, no? Opposite poles. But I'm sure when you passed this resolution in 2009, Mr. President, in the joint session that you had, you were pushing for revocation of the proclamation of martial law.
Well,
Consistent with resolution number 217.
and that was the proper,
That's correct.
that was the proper forum, Mr. President, and the joint session of Congress under the Constitution. That's where the issue and matter of revocation of the declaration of martial law should be properly debated. The other point, Mr. President, that I'd like to point out, Mr. President, is that the current resolution the passed by or authored by 15 is that the Senate, expressing the sense of the Senate not to revoke. In other words, Mr. President, we are now discussing here in the upper chamber merits of the declaration, merits of the debate or deliberation on a martial law declaration.
So-
My belief, Mr. President, is that the discussion on the merits is only valid, will only be valid if it is done in a joint session. People some of our colleagues are saying, well, if 15 of us decide that here in the upper chamber that we don't need to debate it, then we don't have to go to the joint session. My dilemma there, Mr. President, is what therefore is the official record or act of Congress on a declaration of martial law? What official proceeding would be available or would be made to go through the process of debating, Mr. President, or discussing it?
Yes, my understanding of the Constitution is you would need that official record if you are going to revoke.
Well,
And then, Mr. President, does your understanding that the joint session is automatic prevent a House from expressing its own sense on the proclamation of martial law, just like what we did in 388? That's why I was trying to tell you, Mr. President, when we were not in session, that I could separate the two subject matters because so what if it's, let us say, if it's automatic that we need to have a joint session, does that automatically also prevent a House from expressing its sense on the constitutionality or legality of the declaration of martial law?
Mr. President, that's precisely why the nuance here with the resolution 1522 is that we did not talk about revocation or concurrence. We simply expressed the sense of the Senate that the martial law declaration was contrary to the provisions of the 1987 Constitution. I can understand, Mr. President, that it's a, it's a thin line that separates the joint session of Congress discussions and deliberations and the upper chamber. But precisely, we at least, that was the intent then, we did not touch on whether or not we are to revoke or act on the declaration prior to the convening of the joint session, because precisely it is in the joint session of Congress where the merits of a revocation or a concurrence, if that would be the case, would be made.
So, for example, while we were debating proposed Senate Resolution number 388, I was exchanging text messages with the Speaker of the House, and he told me that they see no need, they are not going to agree to a holding of a joint session because they see no need. So that means that their interpretation is it is not automatic in cases of declaration of martial law or suspension of the writ. Hence, we are trying to look for a referee who has settled this issue in cases of a difference of opinion like this. And all we can cite is a Supreme Court decision, Fortune, which I believe holds that the ratio decidendi there, the ruling there is that
It is moot.
the case that we are deciding upon is moot and academic. Hence, we cannot use it at all. So, does the sponsor agree with me that this is still an unsettled issue? Hence, we can rely on our own interpretation.
I would concede, Mr. President.
Lacking guidance from the Supreme Court.
I would concede, Mr. President, from the bar top notcher. But even then, Mr. President, it was an en banc decision. This is a decision of the Supreme Court, and the Civil Code provides that judicial decisions applying or interpreting the laws of the Constitution shall form part of the law of the land. So I agree with you, Mr. President, that this, yes, may be in effect an obiter, but there are other bases. The decision of the Congress to convene when is precedent, Mr. President, and therefore that is another argument in favor of convening the joint session. And we also mentioned, Mr. President, several constitutional tenets: transparency, Mr. President, the right of the public, the right of information of the public on matters of public interest, Mr. President, is there. And of course, accountability, Mr. President, because we are, in effect, acting as a check on the executive department if we go through the joint session to deliberate on the martial law declaration.
As far as past legislative acts are concerned, my point is we are comparing an apple to an orange because the factual situation or the parliamentary situation are not the same.
Well, Mr. President, I may concede again that some of the facts are not the same, but you know that, to be honest, Mr. President, the first statement of the Speaker of the House was that they would convene.
But that is his latest statement.
Well, that's precisely. And when I read that, Mr. President, in fact, when I was unable to attend the caucus, Mr. President, but I had assumed, because I was there in 2009, it was my assumption precisely that there would be no debate on whether we should convene or not. But that's why I was surprised. And when the matter of whether or not it's mandatory or whether or not it's optional really caught me by surprise, because in 2009 the position then that we all took was that it was mandatory. We did not have a debate on whether it was optional. We did not have any of these debates. We all took it, we all assumed, Mr. President, at that point, that it was mandatory for a joint session, for Congress to go into a joint session.
And because the intention of the Senate as a chamber was to revoke.
Mr. President, we did not,
As shown in 217.
well, Mr.
Resolution number
President,
217, that was the-
that was after, Mr. President, that was after, a few days after the declaration, Mr. President. In other words, before this resolution was adopted by 17 senators, we didn't have a real sense of whether or not revocation would have been the course of action. But even without that official document, we already all agreed that a joint session was mandatory.
And then going back...
That was my understanding then.
Yes.
There was no debate as to should we, is it optional? This is my understanding then, Mr. President.
For the record,
Mr. President, with the permission
who
of
were
the
senators then, in way back in 2009, who are still with us?
well, I was the majority leader at the time. May I be, with the permission of Senator
With the permission
Pimentel
of,
and Senator Kiko Pangilinan,
with the
may I just
permission
add
of
to the...
Senator Pangilinan
Just some
and
information.
Senator Pimentel, we recognize Senator Zubiri.
Just for 2 minutes, just an information. I was majority leader then, Mr. President, and I clearly remember that we were united with the father of Senator Pimentel, the senior Senator Aquilino Pimentel Jr., and Senate President Juan Ponce Enrile, that we should have a joint session because we were all in for a revocation. As a matter of fact, we had a shouting match. This is, well, I'm putting it on record. I had a shouting match with Neptali Gonzales, Boyet Gonzales of the House. And as well, not a shouting match with the more senior member, which was the respected Majority Floor Leader Arthur Defensor of Iloilo, when we had the debate in Shangri-La, EDSA Shangri-La. And I clearly recall at the time that the position of the House was it was not necessary for concurrence, but they will respect the Senate because the Senate wants to revoke under our resolution the martial law, the martial law order of the President then. So clearly, the debate, there was debate, Mr. President, but that's because we wanted to convene both houses to show that we were for revocation. Precisely because the elements of rebellion, the elements of invasion were not present during the Maguindanao massacre. It was purely police matter. But yes, I would like to put it on record, the reason why we were very courageous to go to our colleagues in the Senate was because we were for revocation, Mr. President. That's on the record. It was not because it was mandatory. I clearly remember that, Mr. President.
Mr. President, just a clarification, because
Yes, Your Honor.
my understanding then was Senator Zubiri was actually part of the administration of
Yes, Your
President Arroyo, and I don't recall that he was supportive of a revocation.
No, unanimous po yan. We were unanimous. As a matter of fact, I went against the President, who is my godmother, and she was so mad at me, she did not talk to me for several months.
Well, Mr.
I
President,
went against her on that decision.
Well, Mr. President, we then therefore recall it differently, because I recall that there was no debate about whether it's mandatory or optional.
No, this was a meeting that we had, Mr. President, in EDSA Shangri-La. You can ask us, Congressman Boyet Gonzales, who's probably a friend of yours and a friend of all of us, that the shouting match actually took place. And because of that, we're not even very close right now because of that particular incident. Sinabi pa nga niya sa akin, ang yabang-yabang nyo, mga senador. Sabi niya, on the record, yabang-yabang nyo mga senador, gusto nyo lang magpagilas. Sabi ko, hindi naman tama yun. Gusto din namin ipalabas ang posisyon namin that we're for revocation. May sinabi pa nga sa ano ko ba, administration o kalaban? Yeah, sinabi niya, putting it on the record. So basically, that's for the information of the body.
So, one last point, Mr. President. because I asked our secretariat here on how to initiate a joint session with the House of Representatives. The proper way is that there should be a concurrent resolution to
joint.
be approved by, concurrent, to be approved by both houses.
houses.
Meaning to say that this present resolution that we are now discussing must have already a counterpart in the House of our Representatives. So, a factual question, Mr. President. Is there a counterpart resolution already pending in the House of Representatives
I have no idea.
containing similarly the same idea?
I have no information, Mr. President, but I assume there is not. There is no counterpart, Mr. President. Mr. President, in the same way we have a joint concurrent resolution when we convene Congress on a State of the Nation address. That is done by both houses. In the same, when we do joint sessions, there always has to be concurrent resolutions. But nobody debates because it is mandatory under the Constitution. We do not debate a concurrent resolution on convening Congress to hear the State of the Nation address, Mr. President. And
Yes, but
we may disagree, Mr. President, but precisely because of the gravity of the matter and the serious nature and the extraordinary powers that we are giving the President in terms of that the Constitution provides or allows the President to exercise, that is precisely our argument that it has to be a joint session, and it has to be it has to be a joint session of Congress, Mr. President, and it has to be mandatory and not optional.
yes, even when we pass that joint or that concurrent resolution telling the President that we are ready to receive his State of the Nation address, that document is coordinated between the two houses.
Precisely.
Well before the filing, and then so that's why there is no debate, because it's coordinated with the other house. In this particular case, there is no such counterpart resolution in the House.
Well, because precisely, Mr. President, because there are differing interpretations of the joint session of Congress to check on martial law.
Okay.
Mr. President, with the permission of the two gentlemen,
Yes, with the permission of the two gentlemen, the minority leaders recognize.
as pointed out by the sponsor, maybe there is no concurrent resolution. There is no equivalent resolution filed in the House. But nothing will prevent, and I think the proper procedure is, we pass this resolution today, it's a concurrent resolution, and send it to the House, assuming that we pass it here, send it to the House for their concurrence. If we do not pass it, or no, if we pass it and send it to the House, and they do not concur, then there is no concurrent resolution. Right, so we need not debate on whether or not there's a House version. What our position is, we act on the resolution that was filed, resolution 390, and then send it to the House, ask for their concurrence, and let them decide. Thank you, Mr. President.
One final point, Mr. President. Will the sponsor still push through with this resolution, even with the information that the House will not agree to a joint session because their interpretation is that it is not automatic and it is not necessary?
For purposes of record, yes, Mr. President.
Thank you, Mr. President.
Yes, with the permission of the two gentlemen, may the chair ask just two clarificatory
Yes,
questions to the minority
willingly,
leader.
Mr. President.
Thank you. With the permission of my colleagues also on the floor. Does it prevent, of course, the position of the minority shared by some members of the majority is that it is a constitutional duty of Congress to have a joint session. Is that correct?
That is correct, Mr.
Yeah,
President.
and that is the position of the minority. Now, does it prevent the joint session of Congress from affirming the declaration of the President?
No,
Does
it does,
anything prevent? Nothing
No.
prevents.
no, it does not, Mr. President.